I'm David Fowler, and I'm going to give you what might be a minority report on what the U.S. Supreme Court did today, November the 10th, in regard to a request to the court to hear the case of Kim Davis, who is was in 2015 the county clerk in Kentucky who refused to issue a state license to enter into a marital relationship to two men. And I want to suggest to you that the court's refusal to hear the case is great news to my ears if Christians are not sucked into something they may hear that is false. And I'll get to that. Now, just briefly, what happens when the Supreme Court is asked to hear a case? Only certain kinds of cases have a right to be heard in the United States Supreme Court. Everybody else has to file what's called a petition for a writ of certiorari. That's a lot of words, but in essence, you file a petition and ask the court to issue a writ of certiorari. Certiorari meaning to certify, and a writ is just the old English word for an order. So you're petitioning the court to say, would you send an order down to the lower court, in this case, the Sixth Circuit Court of Appeals for the United States, and order them to send all the files up to the Supreme Court because you need to hear this case. And the Supreme Court said today, we don't want to hear this case. Now, that may disappoint a lot of people who were hearing from Kim Davis's lawyers and perhaps other organizations that there was a case pending in front of the Supreme Court where they might grant an appeal and reverse Obergefell. Now, Obergefell had held that states that had licensing schemes for granting permission to enter into a marital relationship could not limit the issuance of those licenses to a male and a female. They had to issue it to any two people, okay? And Kim Davis refused on the grounds of her religious beliefs, that even though she was a government official, I don't have to do this because the First Amendment protects the right to religious liberty. And she lost. As a result, she got sued by these men for a civil rights lawsuit, just like you would sue if you were told you couldn't eat in a restaurant, or told you couldn't stay in a motel, or somebody wouldn't sell you their home because of your ethnicity or whatever it is. They filed a civil rights lawsuit and said, we want to be paid damages for all our emotional suffering because of what Kim Davis did. So this was not a lawsuit about whether Obergefell, that's the underlying case in 2015, was correct or not. It was about how does the civil rights law apply when somebody argues that it can't apply because of my religious beliefs. In fact, the Sixth Circuit Court of Appeals said this about the situation. Let me get it here. It says, Davis is now arguing to the Sixth Circuit that she's entitled to qualified immunity, meaning you really can't sue me for civil rights, because she has, quote, affirmative defenses to liability under the Free Exercise Clause in the Kentucky Religious Freedom Act. Well, see, that has nothing to do with, was Obergefell rightly decided? Could it even apply to me? In other words, she said, okay, it applies, but you can't get to me because I have religious beliefs. So this had nothing to do with Obergefell being right or wrong. It had everything to do with religion. Okay? So the great news is, all the Supreme Court did was say, we're not interested in this question about religious immunity from civil rights lawsuits. They did not say, we're not interested in revisiting Obergefell. That was never the issue. To a lawyer that had read the pleadings and said, this is a religious case about the civil rights law and has nothing to do with whether Obergefell was rightly decided or not. So I'm sorry to disappoint those of you who thought this might be the case that would result in Obergefell being reversed, but it never was. And so what's really good now is that all this religious stuff is out of the way to get to the legal question. Now, let me explain why neither Justice Alito nor Justice Thomas issued a dissent saying, I think we should have heard this case. And both of them have continued to publicly complain that Obergefell was wrongly decided. But see, you have to present the issue as the lawyer in a straight-up way. Is Obergefell wrong? You can't concede that, well, okay, Obergefell applies, but you can't sue me for damages. That's getting to the issue sideways and roundabout. It'd be like me asking my wife when we were dating, for the 5,000th time, will you go out on a date with me, and hoping she'd say, are you going to ask me to marry you? Instead of me just saying, hey, I'd like to marry you. Would you marry me? You see, one's the roundabout way, and the other's the direct way. So this wasn't anything to do with Obergefell. It was about civil rights laws and religious liberty laws. So how can we now present the issue squarely? There are at least two ways I'll offer that I have tried to use here in Tennessee. There can be other ways, but these are the most direct ways to put what Obergefell decided into the crosshairs. And let me read to you what a now retired professor of constitutional law said in an affidavit that I filed in the courts here in Tennessee and gave to our Republican governor and gave to our Republican leaders in the legislature. And he wrote this, quote, "It is my opinion that once a county clerk is asked to issue a license to a same-sex couple, that clerk, should discontinue issuing any licenses until a court of competent jurisdiction authoritatively decides how Article 11, Section 18 of the Tennessee Constitution is impacted by Obergefell." You see, Tennessee says that the only form of marriage allowed in Tennessee is the historical institution and legal contract solemnizing a relationship between one man and one woman. And the Supreme Court never ruled on that. It didn't rule on that in Tennessee. So the question is, can Tennessee still say, well, if Obergefell's correct, we can't issue any licenses? Did they mean to say that? Did the Supreme Court mean to say the only way that anyone can now get married in the United States is if you get permission from the government? Is that really what they meant to say? Did they say all the other understandings of marriage and the marital relationship and how you get into them are now off the table? No, they didn't say that. In fact, Professor Bradley pointed out to me that the court said this is about civil marriages, statutory marriages. They said, we understand that there are other kinds of marriage, and we're not talking about them. So I tried to get our county clerks, I tried to get our governor to just stop doing anything. Just say, I don't know what the status of the law in the state of Tennessee is until the Supreme Court clarifies it. Well, that would have gotten the governor or the county clerk sued, and we'd gone straight up to Obergefell, most likely. And these judges would have had an opportunity to reconsider it. Would they have reconsidered it in 2015? No. But Supreme Court cases don't get there the next day. It would have taken, look, Kim Davis' case is here 10 years later. And we have a different court today than we had back then. Who knows what they might have decided? It would have been exactly what Clarence Thomas and Alito, and I think Gorsuch would have been looking for. But we didn't try. The other way is a piece of legislation that I drafted with some lawyers the Lord brought to my attention. It's called the Marital Contract at Common Law Recording Act. Now, what that statute was saying is that a man and a woman have a historical right, universal right from the beginning of time to enter into a marital relationship. Has nothing to do with any licensing or permission schemes from the government. It exists independent of that. And so a man and a woman who'd have the right to buy and sell a house or a car without getting permission from the government, well, they go down to the government and file an affidavit and say, hey, we are married. There, that's the proof of my marriage. The government hadn't have to give me permission. But because only a man and a woman could file it, you know that homosexual couples would have sued and said, well, that's not fair. We can't file that affidavit. And that would have gone to the Supreme Court and put the issue squarely before the court. So those are at least two avenues in which we can now go after whether Obergefell did what everybody's pretending it did without it being clouded by religious overtones of a government official doesn't have to obey a court order because of their religious beliefs. Assume that they have to obey the court order. But if the United States Supreme Court held as it did that the state statutes are, quote, invalid, end quote, then no official in any state can issue a license to anyone until the state legislature makes that authorization clear. So now it is time for Christian lawyers and Christian public policy organizations to step up to the plate to pursue at least one or the other of these alternatives and perhaps others, and put the issue in front of the Supreme Court. And I hope and I pray they will. If you would like additional information about the things that I've talked about, you can find links to them in the affidavit, for example, on my Substack page, senatorfowler94.substack.com. That's senatorfowler94.substack.com. Thank you.